Good evening, everyone. Thank you for joining us today for this webinar. I hope everyone is at home and safe. And I'm glad that you have been, joining all of the webinars that is organized by Jindal Global Law School. We are glad that today we have Professor Indranath Gupta, who is a professor and dean of research and also controller of examination at Jindal Global Law School. He is also a director of the Jindal Initiative on Research in IP and Competition. So we are glad to have you here. Thank you so much for participating in this webinar. Today he'll be speaking on online intermediaries and the issue of copyright infringement. Also, I would like to tell all the attendees that at the end of the session, we'll be taking question and answers, and Professor Indranath will be answering all your questions. Sir, I will transfer the mic to you and you can take on from here. Thank you so much.
Okay. I think thank you very much, Anshu and Anitya and Anand for inviting me this evening. It's a real pleasure to talk about the issue in hand. Of course, it's a extreme weather condition, and I hope all of you are safe uh, back home and wherever you are. Today we want to touch upon a very interesting area of law, which probably you have heard, a little bit in terms of if you, depending on what where you are and what you have done. It's all about intermediaries and copyright infringement. Now, today's topic is online intermediaries and the issue of copyright infringement. Of course, what you have to do is to connect online intermediaries to the issue of copyright infringement. Who are these online intermediaries to start with? Why is it even relevant to consider online intermediaries in the context of copyright? What and how are they sort of connected, and what are the relevant issues? So I'm going to talk about. I'm not going to use any slides this evening, but I'm just going to talk, straight about. I have few pointers, and going to share some questions with you, and then we can of course have a discussion, as Amshu said, at the end. Now, the outlines, of course, I'm going to go into details of each of these outlines. Outlines talk about why there is a tension between online intermediaries and infringement of copyright. So that's the first question. Why is it an issue at all? Then, of course, how the courts around the world have tried to draw contours of the boundaries of intermediary liability in cases of copyright infringement. And of course, with developments, with the advancement of technology, what are the fresh debates that are happening in European law and European Union and India? We're going to touch upon why it is important for us to definitely look at, at least European Union, if not other jurisdictions, and why is it so relevant for India? Then, of course, and therefore what we want to address this evening is the emerging issues that are coming up in European Union and India in relation to online intermediaries. And number two, how online intermediaries, and perhaps this is the most important question as to how far online intermediaries should be infringements happening on their platforms. So let's start at the beginning as to who are these online intermediaries. Well, pretty much intermediary is a third party providing you a platform, and you are carrying out some kind of exercise on that platform. For instance, you are using Facebook, you are using WhatsApp. For that matter, the platform that we are using this evening to organize this webinar. So all these are intermediaries, and what do? They play a very important role. What kind of role? Well, they usually help to connect, this evening, myself and Anshu and Anubhya and others to you, and therefore they, depending on what kind of intermediaries they are playing the role of a connector. Intermediaries are also, sort of expected to provide internet connection as well. I'll come to that in a minute as to, because that's sort of a very old and, view of what an intermediary is. Intermediaries can also host content, meaning intermediaries can, so for instance, the common example that would come to my mind would be of YouTube, and how YouTube would be hosting all sorts of videos. Um, and really, it's not about just social media that I'm talking about, but it's about other forms of intermediaries as well, and the kind of work that they do. Now, why? So whilst intermediaries play a major role, in bringing about this connection, bringing about the services, about hosting and other related work, there is sort of a tension, so to speak, between the infringements of IP, mostly in relation to copyright. Trademark is there as well, but I'm going to talk about copyright only this evening. Um, there is a tension, when it comes to intermediaries and infringement of copyright. It's nothing new. I mean, it's not that something that has come up in the recent time, but it's not that. It's about 20 years old, I would say. Maybe not. 20 years is a bit of stretch, but um, maybe something in the range of 15 to 16 years, ever since there is sort of an emergence of e-commerce and other forms of commercial activities on the internet, and intermediaries thereby helping, and therefore there was an issue of copyright infringement as well. Now, whilst we are talking about intermediaries and copyright infringement, um, why is it that it is connected to intermediaries? Oh, well, because let's talk about some kind of copyright infringement first, and then we probably would be able to connect it to why they would be connected, why it be connected to intermediaries. Well, the one of the things would be, say for instance, the intermediaries are providers of services, and infringement of any infringement, copyright infringement that's happening on their platform. What kind of copyright infringement? So it may be something as simple as my work, my music, my song, my movie is been sort of uploaded without my permission or without my authorization, and someone authorized it. It's there on the platform of which is online intermediary here, and being accessed by others, users. Probably they have come across, they are watching the movie, they are listening to the song, and so on and so forth. It's as simple as that. Now, how would someone who is a copyright owner, and is meant to sort of protect the copyright, how that person or organization would be able to protect? Well, one thing is informing the intermediary and say that, look, this is what is happening on your platform. Can you please remove? Um, so that has been the norm, I mean, which is called the safe harbor norm. The other way of looking at it is, as an intermediary, you should not let it happen at all to start with. So that's one way of looking at it. And of course, the other thing is that, okay, even if it happens, you should have certain tools to ensure that it doesn't happen again in the future. So basically, what copyright owners probably would sort of think of intermediaries is like a policing role that they should play to ensure that copyright infringements doesn't happen, on their website, on their platform. Why? And the problem is that whilst someone else is maybe maybe playing the primary role in uploading a kind of work, copyrighted work, but then it's very difficult to find that person to start with, and probably the intermediary would be the it is easily intermediary would be easily located, and therefore uh, all forms of expectations sort of connect to the intermediaries. So So in the past, intermediaries have been asked questions about why they have not provided some sort of protection to copyrighted work, why they have allowed infringements to happen, meaning both copyright and trademark, and what have they done to ensure that such infringements doesn't happen in the future. So this debate has sort of gone on for about, as I was saying, 15 to 16 years. And it's not just limited to India, but there are a number of jurisdictions around the world which which have faced these kinds of issues. Now, so we have developed a connection as to why online intermediary and why copyright infringement. To sum it up, it seems that intermediary is the easy sort of target to reach when any kind of infringement is happening on their platform. It's easier to reach out to an intermediary, and therefore the expectation and therefore the connection between online copyright infringement um, and what the intermediary should do regarding that. Um, how the courts have sort of looked at um, you know around the world and how they have tried to draw the contours, the boundaries of intermediary liability, meaning have they actually gone about and said that, hey, you are an intermediary and therefore you are liable? Have they said that, okay, you're an intermediary, but then there are certain boundaries that you have to follow, and therefore you have to keep within that boundary and you can't cross that, otherwise you would be made liable. So it's a mixed bag really, and it's kind of based on the statute, both in India and other countries. um, so let me start with, say, India, and then, as I've told you, at the beginning, that I'm going to talk about European Union as well. So what's happening in India? Well, in India, because it sort of talked about the reference point in 2000 as to when an intermediary should be made liable. But mind you that intermediaries, um, they were not actually, the term intermediary was not used in 2000, in the Information Technology Act. It was network service provider that was mentioned, and of course, network service provider included intermediary. Um, so network service provider, this was a starting point, um, and it's kind of interesting if you think of it. Why network service provider? Well, in 2000, there wasn't much of social media network. There wasn't much of e-commerce to start with. So in those days, intermediaries really played, the role of and sort of hosting and giving opportunity for you to connect to each other, connecting, and therefore there wasn't that much of other services provided as you would imagine, and if you compare it with what's happening right now. So intermediaries in those ways were merely considered as providing connection to the internet, and providing some other features. So network service provider, this concept was essentially looked at from the issue of connectivity, but then there was a change, with time, and up until 2008, there was nothing happened. But in 2008, there was certain amendments that happened in India, and there we find that there is a reference point to the concept of intermediary, and why intermediaries are important, and so on and so forth. So intermediaries, the scope was sort of broadened in 2008 if you compare to what was happening in 2000. However, it was not until 2011 where the guidelines were drawn upon in India, which sort of laid the foundation of what an intermediary must do to absolve itself from any kind of liability. So not until 2012. So you can imagine not much was happening between 2000 and 2011. But it was not until 2012, 2015, 2018, up until recent 2018, 2019, there wasn't even much happening when it comes to intermediaries and mostly copyright cases. There have been other cases as well, but the most prominent ones being the Delhi High Court judgments in Mike Space and Christian Louboutin. That was, of course, the trademark. So MySpace sort of gave the first took the first attempt to interpret what is the status of intermediary of an intermediary in India when it comes to infringement of copyright, and what kind of expectations are connected to the working and functioning of an intermediary when it comes to infringement of copyright. So they relied on the amendments in 2008 of 2008. Not only did they rely on amendments of 2008, but also they relied a lot on the jurisprudence emanating from United States and the European Union. First, to start with what was happening in the United States. Well, United States has a long history of safe harbor. I'll come to that, what it means. And this was essentially started with the Netcom case, the famous Netcom case in the United States. And there the court had the option of looking at the role of an intermediaries, and the court went on to decide that there's a structure that's going to happen, that's a structure that's going to formulate in the United States, and if intermediaries are not given scope um, to flourish, then it'd be quite damaging for them in the future. So they did draw upon the concept of safe harbor, and the safe harbor concept essentially means that in the United States, if you want to absolve an intermediary, there are certain preconditions that must be met. In the same context, you must understand that intermediaries are treated differently in the United States. What do I mean by when they are treated differently? Well, they're treated differently in the sense that they are divided and differentiated based on their nature of service provided. So a social media network would be different from, say a Google or a provider or an e-commerce portal, so on and so forth. So intermediaries are treated in a different way. Of course, as I told you, in the United States, that's the structure. And safe harbor being the crux of it. Now, when you come to European Union, they also have a very rich history. So in European Union, starting from year 2000 onwards, they had the famous e-commerce directive, and then of course they had a number of other directives as well. But most prominent ones would be the e-commerce directive and the DSM directive, Digital Single Market Directive in 2019. Now, these two directives are poles apart. Well, you can say poles apart because e-commerce directive, and I'm only talking specifically about the liability of intermediaries. E-commerce directive talked about that intermediaries do not have a general obligation to monitor their websites. However, if they have knowledge, and that to actual knowledge and not constructive knowledge, then they should act upon. And if they do not act upon, then they would be made liable. Now, the question is that, so what is the difference between the United States and European Union, the United States, safe harbor intermediaries being treated differently. European Union, uh, again, no duty of no duty or no obligation to monitor, uh, and but intermediaries are sort of treated in a separate, in a same way, meaning it doesn't matter what kind of intermediary you are. So that's the difference between US and European Union. However, that difference sort of was kind of, the line was blurred because immediately the point that was raised, in the DSM directive was, the responsibility of an intermediary should depend on the not only the nature but on how big an intermediary is on that aspect, and not really on the kind of work that they are doing. So when it came to this context, the DSM directive, they have now triggered sort of uh, a vertical, approach, so to speak. So vertical meaning intermediaries are classified and categorized, and then the duties and responsibilities are assigned. Which was, so if you look at the previous sort of version under the e-commerce, that was not the case. That was, they had a very horizontal approach. So meaning, like everyone on the same line. Now, so when it came to the DSM directive, it seemed that intermediaries are being sort of more are sort of expected from intermediaries, and not really, they are um, easily absolved from the responsibility. And so when this happened, we also have, in relation to, the so if this is what is happening in the European Union, then what's happening in India? Well, what kind of approach did India follow? And I was referring to the sort of MySpace case in Delhi High Court. See, MySpace looked at the DMCA structure, the basic structure, that intermediaries would not be held liable unless, of course, they have not followed certain norms. So they started with that norm. So that's the US model. Then they went ahead to look at the European model. What is that? The e-commerce directive. Of course, there was no DSM directive at that point of time. So they looked at the e-commerce model, and they said, look, the European model also follows kind of a horizontal approach, and India is very keen and very close to following the European approach. Now, when it did, when it said that, that India followed the European approach, and they went on to add few things as well. They said that, like an intermediary should not be asked or expected to manage its platform, and it's all depends on actual knowledge and not really constructive knowledge. Uh, these are the two interesting terms, the what is actual knowledge, what is constructive knowledge. And this is where, the notice and takedown sort of, comes into play. And then, of course, there are issues like, mostly in case of constructive knowledge, either you have been informed or you have gathered information. Further on, you probably, you had the information of, because there has been a case of infringement, and you would say that, um, if one infringement has happened, and therefore there would be a number of other infringements happening at the same time too. While the court had these two options, they went on to say that, look, as an intermediary, it's not possible because of the volume of transaction, because of the volume of information. It's not possible for you to look at and keep a track of everything which is coming your way and which has been hosted on your platform. However, if you have been informed in a particular format, then you have the responsibility to ensure that that you follow that norm and take down the infringing content. And there you have a possibility of taking down or takedown approach, which comes under the DMCA and also the rubrics of intermediary uh, in the United States. And of course, in India, we had this, in India we had this, sort of norm followed in the DMC in the MySpace case as well, when it was held that MySpace is, um, something should not be held liable for the infringements they were not aware of. And if they are not aware of, then they cannot be said that they had the actual knowledge. If they didn't have the actual knowledge, then they possibly cannot, come under intermediary liability. But this is something which is also quite important here. Is okay, uh, that's about the rule, the thumb rule that intermediary should not be held liable, and so on and so forth. And they should not be uh, taken to, they should be absolved from all kind of responsibilities. Now, when it comes to intermediary responsibilities, what did the court, further on, what did they say? See, there was another opportunity, but that was again with respect to trademark, so to speak, and it was not with respect to copyright. But there is a constant change that is happening, and with respect to trademark, there was sort of a lot of expectations, not so much with copyright. But the changes that were happening, with respect to advancement of technology and uh, fresh debates happening in the European Union and India. Now, what were the debates like, in European Union and India? Uh, See that one of the debates that started in European Union was with the passage of the DSM directive and the expectations surrounding the role of intermediaries. The other debate that started in India, of course, was because of the passage of the draft amendments, again, sort of redefining the role of intermediaries. So, and the expectations mentioned therein essentially means that a lot of times intermediaries would have greater responsibilities when it comes to copyright any forms of infringement, let alone copyright infringement. Um, the question that would come to my, it's an extremely broad topic with many contradictions. So the idea was to give you some sort of snapshot of what's happening around the world. The question that perhaps that we're going to end with is, how far online intermediaries should be made responsible? Uh, should the entire responsibility be bestowed upon intermediaries? If the the intermediaries have been given responsibilities, what would be the framework like? Should India follow the European norm? Should they follow the US pattern? Should there be a hybrid model? So on and so forth. If intermediaries are expected to uh, be be the police or do all kind of policing work, then what would be the nature of their services, the biggest question that we have to ask is, um, then how would you assign, how would you define the word intermediary? How would you assign sort of a role to an intermediary? There is an existential challenge, so to speak, connected to the working and functioning of an intermediary. So the intermediary, the word ceases to exist. There is no intermediary no longer. If you're policing, that means you are looking at each and every content. You are looking at tracking each and every content. You are ensuring that none of the contents are infringing in nature. And as an intermediary, to start with, the idea of an intermediary is not looking at a content or reviewing a content and then ensuring it is passed on and so on and forth. So that's not the objective. However, because if that's the objective, then there is no point in having an intermediary, right? Intermediary essentially is a conduit. It's a channel through which you get information. Now, if you are uh, making the channel liable, right? A channel, not the TV channel, sorry. So think of intermediary as a conduit, right? If you're making that, it's not a TV channel. That TV channel would look at all the forms and so on and so forth and then publish. Because then the volume of data would, it's with an ever increasing volume of data, intermediaries would have a much bigger role to play. So therefore, I say that there is an existential challenge when it comes to um, assigning more responsibilities on intermediaries, and we have to be extremely, extremely cautious about deciding what should be the role like. If you go back to the Netcom case, as I was referring to in in India, in the United States, the DMCA, and the Netcom case decided the fate of intermediaries at that point of time, only to ensure that um, that intermediaries are not taken to court, and they can sort of provide the service, not because they have intentionally uh, you know provided a platform where infringements can happen, and if they are playing a negligible role in sort of just providing a platform and that's about it, nothing more than that, then they should not be made liable. So if that is the role, sort of coming to the you know as to the intermediaries, and then the problem is that what would what would happen in India, like if that is the option which is coming up. Well, in India, before we assign a role to an intermediary, we have to ensure um, that we engage with intermediaries in a way that they do not are inundated with requests and everything. Some say that there are proactive measures that should be taken up. Some say filtering is something that would help to reduce this infringement. Some say that if infringement is something that's going on at this level, then intermediaries should be alert, and there is no sort of correct sort of a defined approach, so to speak. Um, if we look at the guidelines provided, and is the one before the amendments, the intermediaries essentially were given a plan was sort of there was a charged out for intermediaries, and that plan suggested that intermediaries should not uh, be made liable unnecessarily. But if you look at the changes, and there are options, I mean, if you look at the in a nuanced manner, even the changes that are happening, uh, those changes are happening for a reason as well. I mean, no denying the fact. But even if that is what it is, but we have to think that they should not be overburdened. Intermediaries should not be overburdened with more and more responsibilities with advanced and therefore everything should be assigned to them. That should not happen. So drawing a conclusion to start with, it's easy to target an intermediary because it's there. In the last 20 years or so, there is a gradual increase of how intermediaries should behave or what would be the role. With time, intermediaries have been asked to play a rather stringent sort of role, and they have been asked to, do a policing job, so to speak. Uh, the the things that are coming up, in terms of the reflections from United States and India and European Union. India is sort of, it's sort of still there. It's very, young in the sense that we haven't had much sort of discussion. There have been cases, but not as many as one would expect in the United States and in the European Union. So the reflection, the trend which is been observed in European Union and United States is the following. In the European Union, it's becoming more and more stringent. Expectations are more and more from an intermediary, depending on the size of the intermediary, the footfall, the traffic, so on and so forth. And the question is whether India should follow. I would say India should wait and watch, and do not jump into a situation wherein more responsibilities are assigned only because intermediaries are reasonably easier to find. I stop there, and I thank Anshu and Anudya and Anand. Thank you.
Thank you, sir. That was a really enlightening session. Now we have some very interesting questions with us, and one by one, I will just keep asking you those questions, and it would be great if you can answer those for our attendees. So the first question we have is from Pramod Malik, and he says, is it just to fix the liability of intermediator or accountable for which they are not liable, as in the case of DPS MMS case?
See, that's what I'm saying, that if you think of an intermediary, right, they would be, it's easy to find them. I think that's important. I'm not saying that there shouldn't be any responsibility assigned to an intermediary. There would be, and it is important to draw up a structure, a plan, but do not assign much of a responsibility, so much so that there are no intermediaries at all. So then intermediary, the existential challenge is there. No longer there would be a term like intermediary. Then they should be made a party to the entire transaction. That is what is happening right now. They are becoming party to a communication, to an infringement, to any form of social, a social question, so on and so forth. Now, it is very difficult to create a boundary saying that you have to work within this well-defined platform. If you are not, then you are made liable. But that platform, this well-defined platform, even though it is difficult to define it in this day and age, nonetheless, it is important to ensure that there is a concept called intermediary, which has no role to play but to act as a conduit. I know there have been in the past number of incidents where intermediaries have been asked to monitor, closely monitor. Now, closely monitor, you can also think of issues like copyright. I mean, today's topic is copyright. The issues of how would you know that is something is fair use or fair dealing, for that matter, right? Would an algo be able to sort of filter fair use from an infringement? What would be the transaction cost? Does it mean that every item that we want to access would require some amount of money assigned to it? So all these questions should be also added. And I'm no way saying that intermediaries should not be asked questions. They are equal party but they have a special status, and that status should be maintained.
Thank you, sir.
Yeah.
So the next question is from Medhavi. She's saying she would be very grateful if you could share an illustration explaining constructive and actual knowledge in the present context.
Yeah. So say for instance, what is happening these days. So there are two sides. One, the takedown approach. That the takedown approach happening based on that there is a format, and there is a given format. So consider say Singapore or say India or in the United States. There is a format. There is a grievance officer, and you just write to the intermediary for taking the thing down, where you have to pinpoint the infringement. The question is that the fact that I have been able to point out to that infringement, right, doesn't mean that there would be other infringements that are already there, and intermediaries are made liable to take down everything, which essentially means shutting down of an intermediary, right? Because for instance, there, like it's just like it's a very sort of interesting sort of area of law, that should you be have some general idea about intermediaries infringing or infringements happening, or should you be specific and provide some actual knowledge about that that intermediaries have been informed and they therefore should take it down. So at least in the MySpace case, the court said that there is an actual knowledge which is important, actual and specific knowledge which is important, because intermediaries should exactly know the kind of infringement happening, therefore they are able to take it down. And if you are trying to fathom, that one infringement has happened and therefore there are other infringements, then look for it, ensure that doesn't happen, then it essentially means that you are shutting down the entire service altogether, which was not a sort of a welcome. Of course, you know, uh, what is happening in copyright uh, is it's quite different from what is happening in trademark law. So it depends on the kind of infringement, and that is also something which has been observed in the European Union, um, because it seems that more and more, um, just to give you an example, that although there is no actual obligation, and this is I'm referring to Article 15 of E-commerce Directive in the European Union, which was enacted in 2000. Under Article 15, there is no duty, general duty or obligation to monitor, right? Which essentially means that you need not police. However, if you have been informed, how would you ensure that if you have been informed, there the actual knowledge and constructive knowledge would come in? Actual knowledge, specific knowledge, which is what has been talked about, and actual constructive knowledge is something that you construct out of. So that is something which not accepted as of in copyright. But then again, as I told you in the presentation, a lot many times intermediaries have been pushed to the wall. Cases have gone that way, expecting more and more expectations, and mostly it is also something to do with the infringements that are happening on online platforms as well. But then I go back to my initial discussion that there would be an existential challenge if you say that intermediaries are the only ones who would be to monitor, and there would be no one else. Thank you.
Thank you, sir. So the next question is from Mukul. He says that constructive knowledge seems like just another black hole using which the bigger intermediaries can get away from being held liable. And then he questions that what is the scope of the jurisprudence of constructive knowledge in case of the intermediaries, and can the role of intermediaries be defined qua the specific knowledge they have with them? Thank you, sir.
That's a wonderful question, and the fight is all about what is the knowledge that they have. See, we have to understand there is no big intermediary or small intermediary, right? Uh, intermediary, so the idea of an intermediary in 2020, it's very different. I mean, I have seen 2000 as well. You know, I fairly remember 2000, and I see 2020. There was no concept of intermediary hosting services. I mean, there were very few, websites which were interactive in nature, right? Because of the web system and the web 2.0 and so on and so forth. So what would you do? I mean, I agree with the question that you have raised. What would you do? Would you see, if you say that intermediaries should be made liable for everything, right? Then there is no point in them functioning at all, because it's a transaction cost. For instance, how would you feel? And this is a sort of raging debate in the country about consent and privacy, isn't it? While not sort of bordering on any on one side, if you are being asked to give consent uh, 60 times during during 2 hours, every site you visit, everything you do, how would you feel? I mean, consent is required, important, but we have to devise a strategy to ensure that consent is given and consent is taken in a proper way without hampering the way internet functions. Similarly, the functioning of the internet that we have right now completely relies on intermediaries. Therefore, it is important to assign the responsibility and duties in a defined, yet not everything should be on them. So for instance, we are unable to connect without this platform, right? We are unable to connect without Zoom. So and suddenly you have problems with Zoom. Of course, there might be problem. That's okay. But now it's been resolved. That's what I've heard. Uh, but how would you handle that? I mean, would you ensure that they keep monitoring everything that are happening? How would you set up the monitoring process? The problem is that the safe harbor that we have, at least the old safe harbor, that intermediaries being provided some knowledge through a specific mechanism about a specific infringement and then taking it down. Now I understand that also has some problem, because look at the volume of transaction, and therefore now you have intermediaries which are looking at proactive monitoring, and to ensure that that infringements are not happening to that extent. In fact, if you look at the old MySpace case, there was a discussion about MySpace providing online monitoring system. They wanted everything, all the items to be digitally signed so that there was no infringement. So these are the standards being followed regardless. It's not that intermediaries are not doing anything and let infringements are happening all the time. It's not that. But we have to draw a line as to where it should, because it is also about freedom of expression and freedom of speech as well, in terms of looking at the intermediaries liability in this context. Yeah, thank you.
Thank you, sir. So we are short on time and we'll be taking few more questions. The next question is from Raghu, and he says, so he has actually two questions. So I would rather read the one you recently posted. So he says, intermediaries such as TikTok and Instagram buying copyright of sound recording specially from creators so that their users may use them to create more content. So would you
Which is, yeah,
appreciate? Yeah.
okay. So this is kind of observation, right? So yeah, I mean, see, the point is that you so there was, I do not know, like, whether you've been following this issue for a while. On YouTube, you can now buy films and rent videos, right? This was not the case, say, you go back 5, 6, 7, 10, 8 years. So there is a change in the business strategy as well. I mean, it's not that people are sort of, they are, steadfast in their approach. It's not that. Intermediaries has also taken up responsibilities, lot many. But uh, my my apprehension is that yes, buying and providing, using for other services, that's great. But my concern is that any term should not have an existential challenge. Therefore, you challenge the existential framework of how things are functioning. And we are so reliant on intermediaries, which means that they play a crucial role in providing that information, ensuring that everything is done, uh, in a proper way. Nonetheless, they should be given some responsibility, but that need not be the only responsibility. For instance, if there is a copyright violation, how many times would you check, copyright infringement happening on a website? How would you go about? Is algorithm the only answer, that we have? Well, time will tell, but in India, I would say that we have to be uh, really cautious in our approach, because it should not be the case that we should not say that proactive monitoring of the online space is the only way. So that kind of information could also be dangerous. And but proactive monitoring nonetheless could be a way. But how would you monitor? How would you define that space? How would you define that rules? Would be an interesting question. Thank you. Sorry. Sorry, Anshu, I can't hear you.
Hello.
Yes, yes. Right.
Yeah. So, Professor, the next question is from Nitish, and he says, in India, why we have balanced intermediary liability to protect interest of all sides and has no adverse effect on the party?
Yeah, thank you very much. I think the balance, the word in balance is so very important to find that balance. And all cases are fought because of that balance, the word balance, right? See, the worldwide, there is a lot of pressure. In India, of course, if you look at the cases, they followed the norm, like that's a universal norm. But it's too early still in India to say that which way India is going. So if you look at MySpace case, the court is saying that India is akin to mostly the European approach. Now the European approach has changed. Would India be following that approach? That's another next question. Talking about balance, no one knows that, I mean, first, what are the expectations? That's the first thing, right? So if we can find a way to uh, say, draw a line, that these are the expectations, this is your boundary, please don't cross your boundary, then it's okay, right? If we are unable to draw the line, then there would be problem. And even if you draw the line, there would be problem. As I've told you that that there is no general duty to monitor. However, courts have been slowly sort of saying that you have some responsibility nonetheless. So it's very difficult to find the balance, but that is what we are after, that balance.
Thank you, Professor.
Thank you.
Yeah, so maybe this is the last question of the session, and we'll end with the note. So the question is from Sashwata, and she says, under IT Act in India, ISP are intermediary, and once notified about an infringement, they have to block the complaint side. It is, however, difficult to block multiple URL, particularly when joinder order is obtained. It requires resources from compliance and monitoring, which only benefits the business of the other. ISP are not even a party to the content, nor earns any revenue. Isn't it not equitable? Wouldn't there be a cost being provided to ISP?
Okay, that's very interesting thought, and I do not know whether I mentioned that there is a provision in the Copyright Act as well. There is a confusion as to the application of the Copyright Act or the IT Act or the Information Technology Act. Now, see, that's the point. The point is that if it comes to such extent, what is the responsibility that should be assigned? And that is where it all started, meaning you look at the objective of the guidelines. The guidelines clearly say that intermediaries should ensure that the terms of service are clearly laid down. What a person can do or cannot do should be clearly laid down as well, and therefore the privacy policy, the terms of service, the IP rights, the grievance officer, all those are good practices. However, there is no sort of, so to speak, uniformity when it comes to good practices of an intermediary, and whether an intermediary should be. I mean, there are concepts like counter notification. These are the things, of course, I didn't get time to discuss. Counter notification. What are the rights of a party who actually filed the complaint? What would be the issue of what can be the if there is a negligence on the part of misrepresentation, then how it should be handled. There are many bifurcations and divisions in other jurisdictions, and not really in India, and therefore it becomes quite important to ensure that India follows a certain model which need not be always based on either Europe or United States, but something, as we say, someone asked before, that right balance, somewhere in the middle. But as of now, no one knows where that line is, where that dot is. But my fear is that we should not be pushing more towards the left, meaning that intermediaries should be made absolutely liable for everything that's happened on their website. Then it means that you're making them party. That was the objective, to keep them away from being a party. Intermediary, the word now, the name intermediary. So let's see what happens in India. But I'll happy to maybe have some of you, I do not know, maybe as students in JGLS. So yeah. And we'll discuss more. Thank you.
Thank you so much, Professor, for an amazing session. Now, I would want you, if you want to give an end note to all the attendees, maybe something about the topic or anything you like, that would be great.
Yeah, I mean, see, the the topic is extraordinary. I mean, it's very close to my research area, and I think extensive research must be done in this topic. We are doing a lot at our university. Number of our colleagues are working, and there are even like differences if you look at jurisdictions, how their approaches have been. What is the approach, say, and it'd be interesting for you to have a look at what has happened in the United States for the last 20 years to what has happened in the European Union for the last 20 years to what is happening in India for the last 20 years. So mapping the last 20 years of a journey of an intermediary. So that'd be a very interesting area of research for you all to consider. Thank you.
Thank you so much, Professor. I thank all the attendees for joining us today for this amazing webinar, and I hope to see you again for the upcoming webinars, and I wish you a safe stay at home and take care. Thank you so much. Thank you, Professor.
Thank you, everyone. Thank you. Thank you. Bye-bye.
Bye-bye.